On behalf of the Pulmonary Hypertension Association of Canada, welcome to our webinar on medical aid in dying. We're going to have several speakers today. We're going to start with a presentation from Dying with Dignity Canada, and then following that, we'll hear from patient partners Brad Lynch and Marion Brown. I'd like to introduce our presenters from Dying with Dignity Canada, Amanda Coventry-Berridge and Kelsey Goforth. Kelsey is Director of Programs, overseeing education and client support initiatives. She was drawn to the organization by her strong support of bodily autonomy and her belief that talking about death and end-of-life values should be welcomed and not shunned. Kelsey is a requested speaker on end-of-life topics and has spoken extensively to organizations, universities, and healthcare agencies throughout Canada, as well as internationally at the University of Iceland. Amanda is the program coordinator, and she is responsible for the National Webinar Program. She leads the National Independent Witness and Proxy Volunteer Program, and she provides client support to hundreds of people across Canada every year through Dying with Dignity Canada's support team. Originally set for a career in public policy, Amanda was drawn to Dying with Dignity Canada and its mission after the loss of her grandmother, whose Alzheimer's diagnosis redefined her understanding of grief, love, autonomy, and end-of-life choice. We're very glad that they both agreed to come and present for us today. So over to you now, Amanda and Kelsey. Welcome.
Yeah. Thank you so much, everybody, and welcome. I do have a presentation and a PowerPoint accompanying today, so I'm just going to quickly start my slides here, and then we'll go ahead and get started. Okay, Robin, just going to quickly confirm that that's visible for you.
Yep, it is. Looks
Perfect.
perfect.
Okay, well, hello everybody and welcome to Dying with Dignity Canada's presentation on medical assistance in dying. I just want to give a very big thanks to the Pulmonary Hypertension Association for hosting us today and offering their time, and of course to you for offering your time and attention. So without further ado, let's go ahead and get started. So first and foremost, please note that the information provided is accurate as of today's date, February 12th of 2026, and the material in this presentation is provided for information only. It should not be considered healthcare, medical, or legal advice. Furthermore, this presentation is not intended to encourage or suggest to anyone that they should choose MAID. And finally, and most importantly, if you require advice or counsel, or if you have questions regarding medical or legal matters, we ask that you please contact the appropriate licensed professional. Now let's talk a little bit about our organization. For over 40 years, Dying with Dignity Canada has been defending access to quality end-of-life choice and care. Based in Toronto, we are the national human rights charity committed to improving quality of dying, protecting end-of-life rights, and helping Canadians avoid unwanted suffering. We have volunteer chapters across a number of provinces and cities across Canada, and some of the work we do is about planning for what healthcare you may want or not want at the end of your life, what your rights are when it comes to healthcare, and finally, medical assistance in dying, a legal option where a nurse practitioner or physician helps a person to die with specific medications. We are a charitable organization, and we're very privileged to receive donations by many generous peoples across Canada. Let's talk a little bit about our work. So generally speaking, our work falls into three main categories, and starting with the pillar that you see on the far left is advocacy. And some of that work includes lobbying the government for federal legislation and provincial regulation that supports assisted dying and other end-of-life rights, as well as supporting and intervening in court challenges related to assisted dying legislation and policies. Moving along to the center pillar, where you see support, that includes things like answering questions about the MAID law for patients and their loved ones who are considering their right to an assisted death, as well as connecting people with resources and supports. Finally, on the far right pillar, we have education, and that primarily consists of educating people across Canada about end-of-life choice, patient rights, and advanced care planning through a variety of webinars and print resources, in addition to the presentation that I'm offering you today. So with that said, let's talk a little bit now about MAID legislation and the court cases that brought about assisted dying in Canada. So starting on the far left, in 2015, a court case was brought before the Supreme Court of Canada that led to MAID being allowed. Now, this case involved two women in British Columbia who argued that with no option to have MAID, their rights under the Canadian Charter of Rights and Freedoms were being denied. The names of these women were Gloria Taylor and Kay Carter, and the case took on the name of the second person listed, so Carter versus Canada. Now, the law that came into effect was Bill C-14, and it was passed in June of 2016. And it said that a person must have a reasonably foreseeable death in order to access medical assistance in dying. Now, this did not mean that a person needed to have a terminal illness or a short life term expectancy. Instead, it meant that the person's death was reasonably predictable. Now, although many people were able to access an assisted death through this law, many people who were still in pain were unable to access MAID. So, in 2019, two people living in Quebec decided to go to court because although they were in severe pain, they were not able to have MAID because their deaths were not reasonably predictable or foreseeable. Now, this case went to the Quebec Superior Court, and they actually won. And it's named after the two people who brought this case forward, Jean Trouchon and Nicole Gladue. So, because of this case, in 2021, we got a new bill called Bill C-7, which you can see there in the center pillar. It meant that a person did not have to have a reasonably foreseeable death, and it also made some other changes to the existing MAID law that we'll touch on a little bit later. When Bill C-7 was being discussed by the government, there was also a discussion of MAID for those who have a mental disorder as their only condition. Now, it was decided that this should be allowed because excluding people on the basis of their diagnosis was unfair and discriminatory, and that mental suffering is just as unbearable as physical suffering. It was decided that there would be a 2-year wait, and then the ban on those with a mental disorder would stop. Now, this might also commonly be known as a sunset clause. Now, originally, this sunset clause was set to expire on March 17th of 2023. However, as that date approached, the federal government passed new legislation and an extension to the sunset clause. And an extension was put in for 1 year. So that brings us from March 17th of 2023 to March 17th of 2024. Now, again, as that date approached, another extension was passed through legislation, and the new date of implementation for this law is March 17th of 2027. Now, in total, this is a 6-year delay for people with severe treatment-resistant mental illnesses, like 83-year-old John Scully, who has incurable depression, general anxiety disorder, post-traumatic stress disorder, from covering over 35 wars during his time as a journalist with the CBC. It's people with lived experience with mental illness, including John Scully, along with Dying with Dignity Canada, which is representing the public interest, who had launched a legal challenge in August of 2024. With that in mind, let's talk a little bit now about the types of MAID that are available in Canada. So, when we first had a MAID law in 2016, the rules were the same for everyone. However, after Bill C-7 was passed in 2021, we now have two different tracks and therefore two different sets of rules depending on whether the death of the person is expected or predictable or not. So we have track 1 for individuals whose natural deaths are reasonably foreseeable, and track 2 for individuals who meet the MAID criteria but do not have a reasonably foreseeable natural death. We also have two types of ways that MAID is provided to a person in Canada. The first, clinician administered, is when a nurse practitioner or a physician puts a series of medications through an IV. The second, self-administered, is when a patient drinks a medication after getting a prescription from a healthcare provider. One thing to note is that self-administration is exceptionally rare in Canada. The vast majority of MAID provisions are clinician administered. And furthermore, we use the term clinician administered in Canada because nurse practitioners are able to participate in MAID the same way that physicians are. So as opposed to physician administered, we call it clinician administered. And finally, the term medical assistance in dying encompasses both options here in Canada. So MAID through an IV or MAID through a drink. All right, let's talk now about who is eligible for MAID in Canada. So first and foremost, you must be a citizen, permanent resident, or otherwise eligible for public health services. So for example, if you're a resident of Ontario, you might have an OHIP card. This usually means that you have a health card for the province in which you live. So, just as I mentioned, an OHIP card. You have to be over the age of 18 and able to make your own healthcare decisions. You also have to make the decision voluntarily on your own. And after talking to your physician or nurse practitioner, you must know about all of the other options that you could choose. Next, you must have a grievous and irremediable medical condition, which means a serious and incurable medical condition and includes all of the sub bullets that are listed on your screen. Starting with the first bullet, serious illness, disease, or disability. Now, as mentioned, a person whose sole illness is a mental illness cannot access medical assistance in dying until March 17th of 2027. To be clear though, a person that has a mental illness and a physical illness might be able to access MAID. So, for example, someone with a terminal cancer who meets all of the criteria for MAID could still access it even if they have an anxiety disorder. But it has to be so long as that anxiety is not the reason that they're accessing MAID, and it's also not having an impact on how they make decisions. Next up, their situation must be getting worse and it's not able to be reversed. And finally, they have to experience intolerable physical or mental suffering that cannot be relieved under conditions that that person deems acceptable. Now let's talk a little bit about the role of capacity, specifically decision-making capacity. Now, decision-making capacity is required when a person is requesting and being assessed for medical assistance in dying. Capacity in relation to MAID involves understanding the concept of MAID, understanding what their medical condition is and how long they're likely to live with that condition, and understanding what their treatment options are, what the side effects are, and what treatments might be acceptable to them. Now that we've covered eligibility as well as capacity, we're going to talk about the procedural safeguards when somebody applies for MAID. So let's start off first with the procedural safeguards that apply to individuals under Track 1 and Track 2. So first off, everyone requesting MAID must complete a written request. What you can see here on your screen are a few copies of the provincial forms for providing written request. In Ontario, that would be called the Clinician Aid A form. And these are provincial territorial forms that you can find on our website or of any of the provinces or territorial Ministry of Health websites as well. One thing that's important to remember when an individual signs this is that they have to sign it in the presence of an independent witness. And there are several rules as to who can witness, but the most important one to recall and consider is that an independent witness cannot stand to benefit, fiscally, materially, or otherwise, from the individual's death. So, for example, they're not named in the will. Furthermore, every request for MAID must be assessed by two independent nurse practitioners or physicians. And when we're talking about independence, it means that neither assessor can have any power or influence over the other. They can't stand to benefit from the requester's death, and they can't have any other connection that might impact their independence and their impartiality. Moving along, a person can change their mind at any time. They're also asked right before medical assistance in dying is provided if they want to go forward. Now, one time when that does not happen is when a waiver of final consent is used, and we'll talk a little bit more about that in just a moment. For now, let's talk about the procedural safeguards that are specific to individuals under Track 2 MAID. And just remember, Track 2 MAID are for individuals that meet the eligibility criteria but don't have a reasonably foreseeable natural death. Now, generally speaking, these cases are more complex, and the assessment period, so where the person's medical history and experiences are being considered, must be a minimum of 90 days or no less than 90 days. This can also be shortened if there's a significant risk that the individual could lose capacity before that 90-day period, but that tends to be on the more uncommon side. Furthermore, one of the assessors, so a nurse practitioner or a physician, must have expertise of that person's medical condition or consult another practitioner that has that expertise. Furthermore, the individual has to be made aware of the available means to relieve their suffering, and they must discuss them with their healthcare practitioners. Both the person having MAID and the assessor must agree that the person has thought carefully and seriously about all of the options available. And finally, in track 2, immediately before MAID happens, the person is asked if they still want to go ahead with it. Now, we talked before about there's a situation in which this does not happen, which is with the waiver of final consent. So let's go ahead and circle back to that now. So when we talk about the waiver of final consent, we have to talk about how it all began. Audrey Parker was a woman from Nova Scotia who was eligible for MAID in 2018. Now, unfortunately, her breast cancer had begun to metastasize to other parts of her brain, and she became concerned about losing decision-making capacity, which was necessary in order to be able to consent to and receive MAID. Now, despite her wish to spend one final Christmas with her family, she opted to receive MAID early in November to ensure that she had the end of life of her choice. Now, alongside many other changes incorporated in Bill C-7, Audrey's amendment was introduced, which permitted those with a reasonably foreseeable natural death, so track 1, to sign a waiver of final consent if they were concerned about losing capacity before MAID was provided. Now, this is helpful for patients that wish to receive MAID, but are hoping to live maybe a little bit longer. It might be because of a special event coming up, a holiday, as was the case with Audrey, or even though they're suffering intolerably, they're hoping to just get a bit more out of their life. Now, with the waiver, the patient and the MAID provider, so the physician or nurse practitioner that will administer the medications, will provide and enter into a written agreement and set a date for MAID. Now, the patient must still meet all of the criteria for MAID, and they have to complete all of the steps required before completing the waiver. And what it does is it allows the MAID provider to go through with MAID on or by the date listed in the waiver, even if that individual loses decision-making capacity and cannot provide final consent. One thing to note is that a waiver of final consent is not a guarantee. The provider cannot provide MAID if the patient indicates through words, physical gestures, their refusal to MAID. And finally, one thing to remember is that the waiver of final consent is only available to some people. And more specifically, it's only accessible by individuals under track 1 MAID. So the waiver of final consent is not an option for individuals found eligible under track 2. Okay, so just to summarize here, let's review. So track 1 cases are individuals with a reasonably foreseeable natural death. They're generally much more straightforward and faster than track 2 cases. They must be told about their treatment options, and 2 independent nurse practitioners or physicians must agree that the individual is eligible for MAID. Now we move to the right side, track 2. These are individuals who are eligible for MAID but do not have a reasonably foreseeable natural death. But they otherwise still meet all criteria. They have to have that minimum 90-day assessment period. They can refuse MAID at any time and must confirm that they want MAID right before it happens. They don't have access to the waiver of final consent. They have to be made aware of and seriously think about the available options to relieve their suffering. And when they're being assessed and approved, one of those independent assessors must have expertise or knowledge about the condition that they are suffering from, or they must consult with a practitioner that has that expertise. Okay, so now we're going to talk a little bit about statistics and data. And we're going to talk most recently about the information that we have for 2024. So what you can see here on your screen are statistics from Health Canada for the year 2024, and it's the most recent data that we have available from the 6th annual report for medical assistance in dying, which was published in November of last year, 2025. These reports are published about once per year, and anyone can access and read the full report online. You can search up on Google, 6th annual MAID report or MAID reports in Canada, and you'll be able to access it. So what we can see here from the data is that we had about just under 16,500 MAID deaths, which accounted for 5.1% of all deaths in Canada for the year of 2024. And under track 1, we can see that the vast majority of individuals that access MAID did so under track 1, and the median age was 78 years. The most common underlying medical condition that was cited was cancer, and we can see that there's a slightly higher proportion of men accessing MAID under track 1 than women. Let's talk a little bit about track 2 information now. So here we can see that 4.4% of the total MAID provisions fell under Track 2, so just about 630 individuals. The median age was 75 years, and some of the common underlying medical conditions cited were neurological and other. Other typically includes conditions like diabetes, frailty, autoimmune conditions, etc. Another interesting thing to keep in mind is that people assessed under Track 2 MAID lived longer with a serious and incurable condition than those who those who were assessed under Track 1. 34.1% of those under Track 2 lived with a serious and incurable illness, disease, or disability for more than 10 years, compared to 7.4% of those under Track 1. Okay, now let's talk a little bit about what's next. So a special group of members of elected representatives and senators were asked to do a review on 5 key issues related to MAID and end of life. And they wrote a report about the following areas that you can see here. So mature minors, advance requests for MAID, the state of palliative care, MAID and mental illness, and the protection of persons for the protection of persons with disabilities. I won't walk you through all 23 of the recommendations that they had made in their report, but I did want to touch on one that is of most interest to our supporters and about 85% of people across Canada, and that's recommendation number 21. So, recommendation 21 states that the Government of Canada amend the Criminal Code to allow for advance requests following a diagnosis of a serious and incurable medical condition, disease, or disorder that leads to incapacity. So, in essence, an advance request would allow someone to express on paper when they would want to receive MAID in the future. This would allow people who might lose the ability to make their own medical decisions to be able to say that they want to have MAID ahead of time. And it's something that's currently being seriously considered by the government. And they also recently released a report discussing a bit about the discussions that they had had with interested bodies all across Canada. And that's also accessible on the Ministry of Health website. So an advance request involves a competent person making a written request for MAID after a diagnosis of a grievous and irremediable condition that could be honored later after they lose the capacity to make those decisions for themselves. So we have the option of the waiver, but we don't have advance requests. And based on polling that we had commissioned in April of 2024, 83% of people support advance requests for MAID for a person diagnosed with a capacity eroding, grievous, and irremediable condition. And we've also had action at the individual level. Between December 15th of 2023 and February 13th of 2024, a petition was signed by more than 16,000 Canadians from every province and 2 territories calling upon the Minister of Justice to bring about advance requests. So, advance requests are not permitted under the federal law. However, the province of Quebec has decided to move forward with this option on their own. Now, in June of 2023, Bill 11 was passed in Quebec to allow for advance requests in that province, and it began implementation on October 30th of 2024. So we have a bit of an issue now. We have a federal law saying one thing and a provincial law that says another. So how does that work, especially for the healthcare providers who might face repercussions? So in response to this, Bill 390 was tabled by a member of parliament that would provide immunity from prosecution under the criminal code to any province or territory which establishes a law providing for an advance request regime within their healthcare system. Now, while we would prefer to see a change to the federal MAID law rather than a patchwork system, we still see this as a positive step forward. It also should be noted that the Minister of Justice has asked that the Crown Prosecutor's Office not file charges against physicians or nurse practitioners that choose to perform the procedure. And lastly, as I mentioned before, that national consultation on advance requests was held, and it was published in October 29th of last year, and it's available on the website if anybody is interested in having a look. So I do apologize, we're slightly over time. We'll kind of buzz through these slides. I just wanted to share a few resources that might be of interest to you. First and foremost, the DWDC support team is available by telephone and email using the information you see there on your screen. We can answer questions and provide basic navigational support pertaining to legislation, guidelines, resources, or just general inquiries about end of life. Second up is the MAID Family Support Society, which offers one-to-one peer support for those supporting someone choosing MAID, supporting the individual choosing MAID directly, or they might be grieving a MAID loss. Next, I want to highlight Bridge C14. It's another organization available to individuals considering or pursuing a request for MAID throughout all stages of the MAID process. So both fantastic nonprofit organizations. And of course, Dying with Dignity Canada also has a full library of resources on advanced care planning, patient rights, medical assistance in dying, grief, end of life considerations, planning, and much more. All of these resources are available on our website for download free of charge. And if you don't have access to a printer, for example, you might also be able to give us a call and we can definitely send you something through the post as well, free of charge. Okay, as a final reminder, you can stay informed on all things Dying with Dignity Canada and end of life rights through any of the social media channels that you can see there on our screen. And you're also welcome to sign up for our newsletter, which is the best way to stay informed on all updates through us. Okay, I understand now that there's a Q&A period at the end, so I'll actually take questions at the end, but thank you so much, audience members, for your time and attention. And I look forward to hearing any questions you might have at the end of the session.
Thank you so much. That answered so many questions that I had.
Good.
I hope it's the same for others. And now we'll hear from several of our patient partners. I'll introduce them both, and then I'm going to ask him to bring them on. So Marion Brown is a Gitgathla policy analyst, filmmaker, and managing partner of Vision Quest Communications, working at the intersection of Indigenous governance, storytelling, and systems change. With an MBA and Harvard Kennedy School training, she's the creator of the Before I Go podcast and a partner with the Pulmonary Hypertension Association of Canada to develop an Indigenous Advisory Committee, which is going to bring lived experience, policy expertise, and intergenerational care to advance equity and Indigenous sovereignty. Brad Litch is 56 and was diagnosed in 2019 with portal hypertension and in 2021 with pulmonary hypertension. In October of 2024, his disease had progressed to the end stage, and he was given 24 hours to a week to survive. His quality of life was down to 0, and he was living just to live. He signed up for MAID in March 2025, and his death date was going to be August 2025. Okay, so I'll turn it over to Kim to bring, I think we're going to hear from Brad first, and then Marion. Kim, if you want to bring them in.
Yep, I've just invited Brad in.
There we go.
We'll just give it a second. Hi, Brad. Thanks so much for joining us today, and I'll pass the mic to you.
Okay. Well, as was mentioned in the introduction, it's been a really tough decision for me. But my decision to sign up for MAID kind of started in October 2024 and went to April of 2025. That was kind of when I was thinking of MAID. My medical condition got really bad, and I was given 24 hours to live. So I've really gotten to the point of being so close to death. And I fought back and got my health back. But I was thinking, I really don't want to live through that again. It was so difficult that I just could not do it again. So I decided to sign up for MAID. My process for signing up for MAID was relatively easy. I spoke to my nurse that came to see me on a daily basis. She got me in contact with social worker. We filled out all of the forms. She talked about hospice and other possible ways to make it easier for me. We're already on the palliative aspect of care, which is symptom control and just making sure that I'm as comfortable as possible. But I really had no quality of life. I had quantity, but no quality. When we're talking to the hospice aspect, they mentioned to me that I could not have any IV medication. And one of my medications for pulmonary hypertension was an IV grapple. And with that, I decided, well, let's get rid of the IV, go to the pill form of the medications, and at least then I can qualify for hospice. Well, one thing led to another, and having the IV removed for me was probably the best thing, because a lot of my symptoms resolved within 24 hours of having the IV removed. I got so much better, and I felt so much better that I was able to hold off on MAID, not go through with it, and pretty much I'm feeling better now than I did 10 years ago. So the process of going through the MAID opened up other avenues for me. And I know that in the future, I know that MAID is there, and I will choose MAID rather than going through the end of life with pulmonary hypertension. Now I know that I am diagnosed as kind of end stage with the pulmonary hypertension. There's nothing else they can do for me medically. As soon as my liver gives out that's it, there's no other options for me. And knowing that I can choose MAID and go out on my own terms is the one thing that I'm very grateful for, to be in Canada. So yeah, that's about it. I will stick around for question and answer if anyone does have any questions. Let us know. Thank you.
Thanks so much, Brad. We're so glad that you're still here with us. Thanks for sharing your story.
Thank you.
I am just going to bring Marion in. Brad, you can turn your camera off if you want to take a pause, and then I'll bring you back in when we do Q&A. Okay, Marion's on her way in. Hi, Marion. Thanks so much. Floor is yours.
Hi. First of all, I want to acknowledge Brad. What an amazing, the ability to share this very emotional, very personal part of your story. I do want to thank you. I myself I'm feeling a little bit of an anxiety around this. It's a difficult conversation to talk about. It's a difficult subject for you and your loved one. So I just want to acknowledge that, Brad, that I do know where you are right now, sort of emotionally, and the difficulty in being in this space. So thank you, Brad. Thank you for the introduction. I appreciate that. It sounded a little bit like a business thing, but what I do want to do is I have lived with pulmonary hypertension for going on to 8 years now, and I have chosen MAID as part of my end of life planning. But I do want to say that I think part of what we need to discuss is how do we get to that point, and what happens in that process. So, my thinking about MAID didn't begin with my own illness. It began with my mother's cancer diagnosis. And I watched her face death with dignity. She prepared. She said what needed to be said. And she didn't want to leave chaos behind. That sort of helped shape my understanding of dying in MAID. And then my sister, who was also diagnosed with pulmonary hypertension, and she lived 2 years after her diagnosis. And her focus was survival. She had prayed for a transplant, and she fought for as much time as she could get. My mother's, end of life was faced with acceptance. My sister faced her illness with hope. And both are valid. People view their own deaths differently. Having witnessed my sister go through her illness and as it progressed, those questions became very personal. What does dignity mean to me? What is quality of life? What level of suffering am I willing to endure? And those questions became the foundation of my podcast Before I Go. And asking those questions wasn't about death. It was about honesty. It was about autonomy. It was about protecting the people I love. Why did I choose MAID? Choosing MAID did not mean choosing, my death today. It meant reducing fear. It meant protecting my family from, making impossible decisions. It meant, preparation instead of panic. For me, MAID is about sovereignty. It's about clarity. It's about intention. The bigger message I think came from my podcast was, some fight until, the last treatment. Some pray for miracles. Some people accept the natural course. And some choose MAID. There's no single right way. Planning is an act of love. I'm not choosing death. I'm choosing how I will meet it. I'm choosing clarity over chaos, conversation over silence, and preparation over panic. My mother taught me dignity. My sister taught me faith. And I'm choosing intention. And that's how I want to be remembered. Thank you.